Hello and a very warm welcome. You're watching News 9 Live. Joining me in the studio is my colleague and political editor Brijesh Pandey. And the topic in focus is going to be the Delhi versus the central government tussle vis-a-vis the control over administrative services in the National Capital Territory. Now, the Supreme Court of India is set to deliver its verdict over a dispute case between the centre and the Delhi government regarding control over administrative services. Now, a five-judge constitution bench led by CJI D.Y. Chandrachud heard submissions of both the parties for 5 days and then reserved its verdict in the matter on January this year. The case was referred to a larger bench by a three-judge bench led by former CJI N.V. Ramana on the centre's plea on the 6th of May, exactly last year. The question of control over administrative services required further examination, according to the three-judge bench. The centre, on the 27th of April last year, requested a reference to a larger bench, arguing that it needed the power to transfer and appoint officers in Delhi due to Delhi's status as the national capital and the face of the nation. The court also acknowledged that the constitutional bench's authoritative pronouncement was necessary to address the limited question regarding the legislative and executive powers of the centre and the National Capital Territory of Delhi concerning the terms services as per Article 145 of the Constitution. Now, Article 145 of the Indian Constitution mandates that cases involving significant questions of law interpretation or references under Article 143 must be heard by a minimum of 5 judges. The court's focus here is lying on the same interpretation of some clauses in Article 239AA of the Constitution that pertain to special provisions for the NCT of Delhi. The previous constitutional bench did not specifically address the impact of Article 239AA and its subclauses in relation to entry 41 in the state list. Entry 41, ladies and gentlemen, concerning to state and public services. Now, Article 239AA was introduced through the 69th Amendment in 1991. It granted Delhi special category status. This came about following the recommendations of the S. Balakrishnan Committee, which was established in 1987 to address Delhi's demands for a statehood. Now, under this provision, the NCT of Delhi has an administrator and a legislative assembly. Subject to the Constitution's provisions, the Legislative Assembly has the power to enact laws for the entire National Capital Territory or any part of it pertaining to the matters in the state list or the concurrent list, which is applicable to the Union territories. However, exceptions apply to police, public order and land issues. Now, this case has reached the three-judge bench later on because a two-judge bench had previously, before this three-judge bench, had delivered a split verdict on the issue of services. In 2019, judgment by Justices A.K. Sikri and Ashok Bhushan, several issues regarding the powers of the Lieutenant Governor were settled, but they differed in their ruling on the matter of control over administrative services. Now, almost 5 years ago, another constitutional bench ruled in favor of the Aam Aadmi Party-led state government in a similar sort of a dispute. The ongoing legal battle, it has been protracted, no doubt, and the current Supreme Court bench is now going to determine the outcome of this complex issue. Joining us on the broadcast as we expand this particular discourse and discussion is also legal editor and my colleague Ashok Bagria joining us here on the broadcast. You know, Ashok, I'm going to begin with you. How about you help us understand what are going to be some potential implications? What is this long drawn protracted legal battle all about? We've got an Article 143 in play here. You've got an Article 239AA and several clauses of it. Can you help the layman out there understand what's the tussle all about and what could be expected today?
Well, let's put it very simply, that this is a matter which is being very closed by IAS and IPS officers who are in the service of the Delhi government. Now, the issue really here started in 2018 when there was a confusion with regard to what constitutes government under Article 239AA of the Constitution of India, whether it was the Lieutenant Governor of Delhi or whether it was the elected government of any political party which comes to power. So there, the matter was referred to a bench of 5 judges, and they decided that as far as the term government is concerned, it will mean the elected government. The Lieutenant Governor is not the government, and the Lieutenant Governor will have to act on the aid and advice of the Council of Ministers. Now, this was a broad proposition or a principle which was laid down by a bench of 5 judges of the Constitution in 2018, but there were still smaller issues which were still pending. For instance, that who will have the control of officers who are employed or who are in the service of the Delhi government. Now, this is one question which has become a major source of tussle between the Lieutenant Governor's office and the office of the Chief Minister, which is led by Aam Aadmi Party Chief Minister Arvind Kejriwal. There has been constant bickering between the two, saying that the Lieutenant Governor is acting in a very unilateral and an autocratic manner, does not consult the elected government, which is led by the Aam Aadmi Party. So today what we are going to see is that whether the power to transfer and post out these officers, these central government officers who are in the employment of the Delhi government, who can do this. So far, the position in Delhi is concerned, all these transfer and postings are done by the Lieutenant Governor's office, and the elected government has no say in these transfers and postings. Now, one of the arguments which was made in the Supreme Court during the hearing in this matter was that how can an elected government actually function without controlling the officers who are in charge of executing various policies of an elected government. Whereas on the other hand, the central government defended the powers which vested with the Lieutenant Governor, saying that as far as Delhi is concerned, the national capital or national capital territory of Delhi is concerned, it enjoys a very unique position. And the national capital is of very strategic interest, and therefore the power to transfer and post out officers vests with the central government. And here they also made it clear to the Supreme Court of India that there is no violation of this principle of federalism which is violated. And federalism is one of the very cornerstone principles of our constitution in which this country functions, where there is a union government, where there are state governments, and there is clear delineation of powers as to in which areas will the central government exercise powers and which areas the state governments will exercise power. So today, what the Supreme Court is going to do is it will try to put to rest this whole controversy over who has the power to transfer and post central government officers who are employed with the Delhi government.
All right. Well, that's very eloquently put for all the viewers out there. Essentially, power of transfers of these postings of various IS officers. So, the battle of control over administrative services. Joining us also on the broadcast is KC Mittal, constitution and legal expert. A very warm welcome to you, sir. Sir, do stay on with us. British, I'm going to come to you next. You know, be it any lieutenant governor, Ms. Jung, you've got Anil Baijal, now Vinay Saxena. The tussle between the Aam Aadmi Party government, Arvind Kejriwal being the face of that particular tussle, versus the Lieutenant Governor representing the centre. This flashpoint, I mean, the list is ever increasing already. Do you think today's particular verdict is going to finally, give some sort of solidarity to the kind of pressure the Aam Aadmi Party government has been putting on the centre, and vis-a-vis, I mean, vice versa, you've got the centre putting equal pressure on the Aam Aadmi Party government?
Well, I think what this today's judgment will do is that it will settle once for all the contentious issue of who will get to transfer and post the officers who report to Delhi government. Because this flashpoint is there because Delhi enjoys a unique status, and if you go by the MHA directive, LG in effect kind of virtually means the Delhi government. The LG has various powers, and in the last judgment it was said that it clipped the powers of LG and said that that LG cannot act unilaterally and act on his own, and it has to act on the aid and advice of the elected government. But massive power tussle is going on between the LGs, as you mentioned, Baijal and Najib Jung before that, and with the current LG as well. I think it's politically contentious because everybody wants to own the bureaucrats who are running the post. Aam Aadmi Party says that until and unless it gets the power of deciding who stays with them and who they have power over to transfer, the bureaucrats will not listen to them. And this is the reason why there has been also constant skirmishes between the government and the bureaucrats as well. And LG says that LG through centre says that it has given its unique state, it is an absolute power when it comes to transfer and posting. So that is the reason why last time, when 3 judges bench were there, it's that the centre had requested the Chief Justice to transfer it to a larger 5 judges constitution bench. And I think today's judgment will once and for all settle most of the contentious issue vis-a-vis the Lieutenant Governor and Delhi Chief Minister.
Well, absolutely. We'll have to wait and watch. Minutes from now, we're going to get that crucial verdict in this particular case. K.C. Mittal, constitution and legal expert. Let's quickly go across to him. Mr. Mittal, could you explain the significance of Article 239AA and the subclasses that are involved here, bracket 3, bracket A of the constitution, and its interpretation in relation to the control over services, especially in Delhi?
See, let me tell you, basically, as far as Delhi is concerned, there has been an issue because of 2 seats of governance in Delhi. One central government and another Delhi government. As far as Delhi government is concerned, prior to constitutional amendment of bringing in Article 239AA, the assembly only had advisory power. There were elections held, no doubt about it, but they had no power to legislate. The question even at that point and that was known as Metropolitan Council, you may be aware of it. The problem here is the central government and Delhi government, you can't have 2 parallel governments running as far as Delhi is concerned. And that was the reason why at some state point of time, there was a thought which was being considered to have a mayor in council to carve out certain area, particularly the areas within the within the jurisdiction of NDMC, so that the central government have the exclusively jurisdiction over there and the rest of the area can be governed by the Delhi government. But even that didn't get materialized and perhaps the idea was dropped. Then comes the question that for all purposes under the constitution, no doubt, Delhi remains as a union territory. But even as union territory, your powers under Article 239AA are not diluted or in any manner taken away. The constitutional amendment gives exclusive power to the Delhi Assembly as to legislate, as also the executive powers to the government elected in respect of transfer subjects. Barring 3 subjects, as you know, police, public order and land. Therefore, all those 3 subjects are not with the Delhi Assembly or the Delhi government where they can legislate or have the executive power. But in rest of the subjects, they enjoy powers at par with the state government. That was the whole idea and purpose, that the duly elected government at Delhi, in exercise of powers given under Article 239AA,
right,
they are competent to legislate as well as have the executive power. And that's the reason why the Supreme Court has also clarified this aspect of the. Why should there be a provision under 239AA that the administrator, that Lieutenant Governor, will act on the aid and advice of the Council of Ministers? That power is not with the state government. The state government also functions in the same
right.
fashion.
So essentially a dilemma at play over here over the control of administrative services. Ashok, I'm going to come to you next. You spoke about the arguments that were made in the court. Representatives of the Delhi government saying that, why even elect a government when you're going to, curtail our powers? And at the same time, the centre also saying that it's the face of the nation, it's the national capital. We must have, control over the national capital as well. But the significance of entry 41 in this particular list, can you help us understand what are some previous arguments that have been made, and how will that impact in shaping today's particular decision, and throw some light on, entry number 41 of the state list as well?
Well, as far as the Delhi government is concerned, they're very clear in their arguments. They say that the Delhi government enjoys a special status under the Constitution of India. Now, under the Constitution of India, there is this concept of federalism, or which is called sharing of powers. And under that concept of federalism, there are certain subjects under the union list on which only the central government can make laws. Then there is a state list in which there are issues or there are matters on which only the state governments can legislate. And there is a concurrent list on which both the central government and the state governments can make laws. Now the problem starts with entry 41 of this particular state list, in which the central government, by an amendment in May 2015, removed the word services. So what the central government did was they made a law and said that we are just clarifying that entry 41 has the term services, which includes the civil servants who are in the employment of the Delhi government. Now the Delhi government, once we remove them from the state list, what it will mean as far as the Delhi government is concerned, that the Delhi government will have no power to transfer or post out any civil servant who is employed with the Delhi government, number one. Number two, there was a subsequent notification also which was brought in somewhere in 2021, where the central government, to bypass the 2018 judgment, said that hereby we are making it clear that as far as the word government is concerned, it will mean the Lieutenant Governor of Delhi and not the elected government. And to buttress their arguments, the Solicitor General of India, who was appearing for the Union of India, said, look, you have to understand that Delhi is the national capital of the country. It has a very strategic importance. It is different from other union territories, or for that matter, other states. Thirdly, he said, when we talk about these things, we have to keep in mind the concept of federalism, that is the sharing of powers between the union government, state government, and the union territories. But at the same, also you have to keep in mind whether it will compromise such sharing of powers will result in compromising strategic interests. So there, the argument made by the Solicitor General was that, look, we can understand everything. We can understand the concept of federalism. We can understand the idea of sharing of powers. But what we can't understand is that, look, you have to keep in mind the fact that Delhi is not an ordinary union territory. This is a union territory which is the capital of the country. This is a union territory which has a very strategic importance. This is a union territory where the government believes that if they have the power to transfer and post out officers, the idea of a successful and a fruitful government will be met. However, all said and done, this argument was very beautifully met by senior advocate Mr. Abhishek Manu Singhvi, who appeared for the Delhi government. He said, look, I can understand whatever the central government is saying, but please then explain to me, how do you explain the idea of Jammu and Kashmir? See, after Article 370, the state of Jammu and Kashmir was divided or, trifurcated into 3 union territories. Now, Mr. Singhvi told to the court that, look at the union territory of Jammu and Kashmir. There, the union territory of Jammu and Kashmir, or the elected government or the lieutenant governor there, has the power to transfer and post out officers in Jammu and Kashmir. Then why are you denying it to only Delhi government? Because then he said that there is actually more to this whole opposition by the central government than meets the eye. And there is definitely some level of politics which is also playing out as the courts is hearing this case. So today what we are expecting is that once and for all the central government, the Supreme Court will step in, put this whole controversy to rest. So once this controversy is put to rest, it will be decided whether Lieutenant Governor on the aid and advice of the central government will transfer and post out central government officers, or will it be the elected government in Delhi which will have that power.
You know, Ashok, also tell the viewers, you know, considering we've already seen a split verdict, albeit it was a two-judge bench in this particular matter earlier in the, in 2019. But at the same time, you know, help the viewers understand, is a split verdict again possible? Can the bench throw up another split verdict? What are some possibilities over there?
Yes. It's completely possible. There are 5 judges, 3 judges might agree, 2 might disagree, 4 judges might agree, 1 judge might disagree. So there is always a possibility because judges can always disagree. Now, in the past, what we had seen in 2019 was that this matter of services was before a bench of Justice Ashok Bhushan and Justice A.K. Sikri, and both of them disagree. Here again, we have a similar situation that the matter has been referred to a constitutional bench for interpretation. So there is all the possibility of a disagreement here also, or a split verdict, which then again will have to be dealt with the Chief Justice of India by referring it to a larger bench.
Well, absolutely. So this particular dispute could go on longer, can be more protracted. You know, Brijesh, Ashok here talking about the J&K example that was used by Manu Singhvi appearing for the Delhi government, citing the J&K example. When they have those kind of powers, why not us? I mean, J&K, a more, tense-ridden area than the national capital. Safely going to assume that over here. Would you like to resonate on, I mean, the politics at play? He's talking about the politics behind.
He was also stressing upon the fact that, you know, the center's argument that Delhi enjoys a unique status and, you know, the security paraphernalia has to be with the center. It was a very pertinent counterpoint by Abhishek Manu Singhvi, who was appearing for the Delhi government. And, you know, the argument holds weight because, the state of Jammu and Kashmir is a far more, you know, when it comes to security and all, is a far more challenging area for the government than the national capital. And the fact is that, yes, when the government there has the power to, you know, transfer and decide on the transfer and posting, why can't the Delhi government, which is headed by Aam Aadmi Party right now, have the same power and privilege? It will be interesting to see how many judges vote in favor of this and how many judges go against, and it is accepted by a 3-2 verdict or a 4-1 verdict. We'll have to wait and watch for a while, because we've been given to understand that, you know, the references have been over and the 5 judges Supreme Court bench, constitutional bench, is going to sit in another couple of minutes. So I think, I mean, another 5-7 minutes, you know, the picture will be clear. But one thing I can say for sure, Kabir, is that this judgment will have a massive ramification on how the Delhi government functions. If it goes Delhi government way, you know, it will lead to a fresh bout of assertion by Aam Aadmi Party, because they feel that, you know, with law and land outside their purview and this transfer posting outside, it virtually makes them defunct. But if it goes their way, I think it's going to be a game changer as far as the politics of Delhi is concerned. That is the reason why, you know, it's a very, very important and crucial judgment, which is the Constitutional Bench of the India, of the Supreme Court, is going to deliver in some time.
Right. I mean, from where I'm looking at it, and I'd like to, urge all the viewers that are watching our stream right now also to get down in that chat box and send us your questions. We've got legal experts, we've got a political editor on the panel right now. Send us your questions. We'll take them right now, as in when you send us right here live on the stream. But, you know, Ashok, Brijesh, at the same time, the morale boosting factor, if this goes the Aam Aadmi Party way, then it's another morale boost for the Aam Aadmi Party government in the national capital. They just won the MCD polls as well. And this decision, if it goes the Aam Aadmi Party's way, it's going to be another morale boost, even as 2 of its prime ministers are languishing in jail.
Well, I think it's going to be a massive morale booster, for the government, for the Delhi government, because they will treat this as a victory, and it will be a victory of sorts for them. No two ways about it, because then they will get to control the bureaucracy, which Arvind Kejriwal has said time and again that
they're not listening to us.
they're not listening to us because we don't have the power to post or transfer, and that is our key detriment when it comes to handling bureaucracy. So it is going to be a big victory if it goes their way. I think it's just a matter of time before we get the 5 judges constitution bench refer to. I would like to take a question which is I've been asked in our live chat by Verghese. It says that what is the actual position of Delhi? Is it complete state or a union territory or this NCR? Delhi seems to be the most political undefined state. Is that the case? Well, I would say that that Delhi is not a complete state. Delhi is a half state. The law and land are the issues which is controlled by the central government, and also the transfer and posting. I think LG has a major say on how the state functions. So yes, it is not unlike any other state of Uttar Pradesh or Bihar, and this is the reason why this tussle which is happening on is going on between the center and the state. We have also seen how the LG representing center there has a massive the last 3 LGs have a massive run-in with Aam Aadmi Party.
Well, absolutely. Gaurav Handa is also asking us this question, quite a pertinent question. Thank you so much, Gaurav, for this question. He's asking, looking at the present scenario, who do you think has the upper hand according to law?
Well, I think, the question, it's an interesting question, which has been asked by Gaurav, but the question is that who has the upper hand according to law is exactly what is going to be defined in some time from now. I think another 4-5 minutes.
But the idea, the perspective, because you've got a lot of people in the national capital who are constantly saying that we're having to elect a government that essentially has not a lot of powers. Why do you even need a government in that case?
I agree.
What Ashok was also talking about, the word government here means the lieutenant governor in that particular notification.
Absolutely.
As well.
I mean, it definitely does defeat. Many people say that a lot of things still lies with the Delhi government, but no government can function efficiently if law and land doesn't belong to them. In this case, law and land doesn't belong to them, but the fact is that even normal cases of bureaucratic postings also is not with the center with the state government, and I think that makes the matter a lot more trickier, because then any bureaucrat would see to it that he doesn't listen to the government or simply bypass the Delhi government and report to the LG, which is currently the case. So I think this particular judgment is going to sort this issue, I guess, once and for all.
Well, absolutely. Let's quickly go across to the legal experts on the panel as well. KC Mittal, constitution expert, with us on the panel. Mr. Mittal, what do you think are some key legal arguments in this case, according to you? Ashok, just a short while ago, threw some light on what he thought were real clear-cut arguments that were being made. The constitution bench has heard both the parties for about 5 days. All those arguments are out there in the public domain. What do you make of those arguments?
I just heard Brajesh, a friend of mine. See, All India Services, that is IAS, IPS, the controlling authority is the DOPT. The officers are posted in various states and union territories. And once they are posted to land to a state government or the union territory, thereafter it is their responsibility of posting them wherever they want. Number one. Number two, apart from that, Delhi has its a combined cadre that is known as Daniks. They are the officers which include Delhi, Goa, and a few other states, union territories, and like that. I think Pondicherry is also, I'm not sure about it, but it's there. Daniks is their own cadre. So the posting takes place within those states. The question today is, let me point out, according to me, there was an amendment carried out in entry 41, state list, in 2015. And then the definition of Lieutenant Governor, government, the Lieutenant Governor in 2018. In my view, Whatever Supreme Court ultimately says is another aspect of the matter which we'll know. But in my view, you have no power to amend Article 239 AA. It was very difficult for the government to amend it. So you thought to adopt an indirect device to cut down the powers given to Delhi government and the assembly under Article 239 AA. How can you do that? You see, I'm just asking a question to anybody and everybody. It is like you are putting a soldier on the border. You don't give him the arms.
Right.
You want the government to be run without services and without the government having the power to post them within the territory where they have been given constitutional powers, legislate and even the executive powers. I mean, I'm sorry, as a lawyer, it's very difficult to reconcile with this kind of proposition. Absolutely, the whole idea, it seems to be, and that has been going on, barring three subjects. 41 is not excluded, state list.
Right.
Entry, except three, and there is some confusion about law and order. I don't want to go into that debate because law and order is something which is under the Criminal Procedure Code and preventive detention, which is part of the concurrent.
I think the judgment is going to be there. I'm sorry, Mr. Mittal, we have to stop you there.
Yeah,
The CGI is starting. We should put a full frame of it and listen to what Justice Chandrachud is saying.
We are unable to agree with the view of Justice Bhushan in the 2019 split verdict. As indicated previously, the majority decision in the 2018 Constitution Bench judgment rendered a broad interpretation of Article 239AA3A to provide NCTD with vast executive and co-extensive legislative powers except in the excluded subjects. A combined reading of the majority opinion and the concurring opinions of Justice Chandrachud and Justice Bhushan indicates that the phrase "insofar as any such matter is applicable to union territories" does not restrict the legislative powers of NCTD. While the 2018 Constitution Bench judgment provides sufficient clarity on the interpretation of the phrase "insofar as any such matter is applicable to union territories," we find it necessary to deal with the arguments made by the Union of India that the phrase must be read in a restricted manner to limit the legislative power of NCTD on certain subjects in addition to already excluded subjects in List 2. Article 239AA3A confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239AA3 provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, Subclause A of Clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2, and 18 of the state list, and entries 64, 65, and 66 of that list insofar as they relate to the said entries 1, 2, and 18. Second, Subclause B of Clause 3 clarifies that Parliament has the power to legislate on any matter for a union territory, including on subjects with respect to which NCTD has legislative power under Article 239AA3A. In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list, Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239AAC provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying, or repealing the law so made by the Legislative Assembly. Fifth, under 239AA7A, Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239AA and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239 AA3 balances between the interests of NCTD and the Union of India. Article 239 AA expressly excludes entries 1, 2, and 18 of List 2 from the ambit of the legislative competence of the Legislative Assembly. 239 AA also stipulates that the legislative power of NCTD is excluded with respect to entries 64, 65, and 66 of List 2, insofar as they relate to entries 1, 2, and 18. Entry 1 deals with public order, entry 2 deals with police, and entry 18 deals with land. When we explain the entries, thus the exclusion of entries 64, 65, and 66 to the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239 AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase insofar as such matter is applicable to the Union Territories as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239 AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239 AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to Union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. Then page 53. The principles of democracy and federalism are essential features of our constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate, one at the level of the national government and the second at the level of the regional federal units. These dual sets of government, elected by we the people in two separate electoral processes, is a dual manifestation of the public will. The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in List 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accountable to the people of NCTD. Under the constitutional scheme, NCTD was given legislative power which, though limited in many aspects, is similar to states. In that sense, with the addition of Article 239 AA, the Constitution created a federal model with the Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the Union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is a concurrent list, The Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239 AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament. Therefore, the executive power of NCTD in the absence of a law by Parliament shall extend to all subjects on which it has power to legislate. It was held Then we cover Rule 46 of the rules, and we say, the rule provides that the Lieutenant Governor shall exercise such powers and functions with respect to persons serving in the administration of NCTD as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President. The term administration in this rule must be considered in the context of Article 239 AA3 and Section 41 of the GNCTD Act. The executive administration by the Lieutenant Governor, in his discretion, can only extend to matters which fall outside the purview of the powers conferred on the Legislative Assembly, but it extends to powers or functions entrusted or delegated to him by the President, or in which he is required by or under law to act in his discretion or to exercise any judicial or quasi-judicial functions. The term administration cannot be understood as the entire administration of GNCTD. Otherwise, the purpose of giving powers to a constitutionally recognized and democratically elected government would be diluted. In a democratic form of government, the real power of administration must reside in the elected arm of the state, subject to the confines of the Constitution. A constitutionally entrenched and democratically elected government needs to have control over its administration. The administration comprises of several public officers who are posted in the services of a particular government, irrespective of whether or not that government was involved in their recruitment. For instance, an officer recruited by a particular government may serve on deputation with another government. If a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying the triple chain of collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. The principle of collective responsibility extends to the responsibility of officers who in turn report to the ministers. If the officers stop reporting to the ministers or do not abide by their directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. We have already held that the relationship between the Union and the NCTD resembles an asymmetric federal model, where the latter exercises its legislative and executive control in specified areas of the state list and concurrent list. Article 239AA, which conferred a special status to NCTD and constitutionally entrenched a representative form of government, was incorporated in the Constitution in the spirit of federalism, with the aim that the residents of the capital city must have a voice in how they are to be governed. It is the responsibility of the government of the NCTD to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive who are charged with formulating policies in the territory of NCTD would be excluded from controlling the civil service officers who implement such executive decisions. The legislative and executive power of NCTD over entry 41 shall not extend over to services related to public order, police, and land. However, legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and the vision of NCTD in terms of day-to-day administration of the region, shall lie with the NCTD. Officers thereunder may be serving in NCTD even if they were not recruited by the NCTD. In such a scenario, it would be relevant to refer as an example to some of the rules which clearly demarcate the control of all India or joint cadre services between the Union and the states. NCTD, similar to other states, also represents the representative form of government. The involvement of the Union of India in the administration of NCTD is limited by constitutional provisions, and any further expansion would be contrary to the constitutional scheme of governance. We reiterate that in light of Article 239AA and the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under entry 41 list 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services as explained above. To clarify, any reference to Lieutenant Governor or over services, excluding services relating to public order, police, and land, in relevant rules, shall mean Lieutenant Governor acting on behalf of NCTD. Now the conclusion. The division of administrative powers between the Union and the NCTD as explained in this section must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239AA3A. D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the 3 entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239AA3 cannot be read to further exclude the legislative power of NCDD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H, with reference to the phrase subject to the provisions of this Constitution in Article 239 AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of list 2 of the 7th schedule, because 1, the definition of state under section 358 of the General Clauses Act 1897 applies to the term state in part 14 of the Constitution. Thus, part 14 is applicable to union territories. And 2, the exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.
Thank you, sir. Lord, immensely grateful to your Lordship.
The petitioners have urged that the order of this court dated 27 June 2022 relied on the decision in Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions. This submission cannot be accepted. Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions in view of the principles of natural justice.
Well, so the verdict has been delivered by the top court. It seems like it has gone the Aam Aadmi Party's way, something that we were talking about as well, Brijesh. A big boost for the Aam Aadmi Party. It seems like he's finally the boss of Delhi.
Oh yes. You know, I mean, all the confusions, it seems, has been cleared by Supreme Court. It has made very clear that, you know, whether the LG is the super boss or Delhi government control. He says that, you know, under 239 AA, it is very clear that, you know, the same parliament has enacted the legislature of national NCTD, and the day-to-day functioning or the day-to-day this
is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted, and 2, whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench: whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, adoption of the following procedure may subserve the objective of the 10th schedule: the symbols order, as well as Article 179C, it may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications which require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 ko correction hai, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3, the decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party which reaches the halfway mark forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve 2 objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable, and such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shiv Sena was chaired by Mr. Uddhav Thackeray in his capacity as the Shiv Sena President, Party President, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the President of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the President of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the Legislative Party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the Speaker inferring that there were two factions of the Shiv Sena. The Speaker, on taking cognizance of the resolution passed by the faction of the SSLP led by Mr. Shinde, did not attempt to identify which of the two persons who were nominated, namely Mr. Prabhu or Mr. Gogaole, were authorized by the political party. In a contentious situation such as this, the Speaker should have conducted an independent inquiry based on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. For the reasons detailed in the preceding paragraphs, the Speaker must only recognize the whip appointed by the political party. The decision of the Speaker recognizing Mr. Gogaole as the chief whip of the Shiv Sena is illegal because the recognition was based on the resolution of a faction of the Shiv Sena legislature party without undertaking an exercise to determine if it was the decision of the political party. Harmonizing the 10th schedule with paragraph 15 of the symbols order. This court cannot accept the solution proposed by the petitioners and lay down a constitutional sequence. To hold that the Election Commission of India is barred from adjudicating petitions under paragraph 15 of the symbols order until the final adjudication of the disqualification petitions under the 10th schedule would be in effect to indefinitely stay the proceedings before the Election Commission of India. This is because an order of the Speaker attains finality only after all avenues for appeal have been exhausted or are barred by the passage of time. The time that it would take for an order of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutionally entrenched institution which is entrusted with the function of superintendence of and control over the electoral process. The ECI, which is a constitutional authority, cannot be prevented from performing its constitutional duties for an indefinite period of time. Proceedings before one constitutional authority cannot be halted in anticipation of the decision of another constitutional authority. In arriving at this decision, it is not necessary for the ECI to rely on the test of majority in the legislature alone. In cases such as the present one, it would be futile to assess which group enjoys a majority in the legislature. Rather, the Election Commission of India must look to other tests in order to reach a conclusion under paragraph 15 of the symbols order. The other tests may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. Then we deal with the judgment in Sadiq Ali's case, and having dealt with the judgment, we say the disqualification proceedings before the Speaker cannot be stayed in anticipation of the decision of the ECI. In cases where a petition under paragraph 15 of the symbols order is filed after the alleged commission of prohibitory conduct, the decision of the ECI cannot be relied upon by the Speaker for adjudicating disqualification proceedings. If the disqualification petitions are adjudicated based on the decision of the ECI in such cases, the decision of the ECI would have a retrospective effect. This would be contrary to law. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both the factions of the Shiv Sena claiming to be the real Shiv Sena. In effect, this points to the existence of a split within the SSLP. However, no faction or group can argue that they constitute the original political party as a defense against disqualification on the ground of defection. The inevitable consequence of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members who face disqualification proceedings. In cases where a split has occurred in a political party or in a legislative party, members of neither faction may validly raise the defense that they are the political party in the event that each faction files petitions for the disqualification of members of the other faction. The defense sought to be availed of must be found within the 10th schedule as it currently stands. The deletion of paragraph 3 impacts the proceedings under paragraph 2(1)(b) as well. When there are two whips appointed by two or more factions of the political party, the speaker, as held in the preceding section of the judgment, decides which of the two whips represents the political party. Thus, the adjudication of the speaker on whether a member must be disqualified under paragraph 2(1)(b) would also depend on the decision of the speaker recognizing one of the two or more whips. We accordingly answer the question referred to us as noted in paragraph 32F of the judgment. To avert a no confidence motion, the incumbent government may not advise the governor to convene a session of the assembly, and the speaker may adjourn the sitting of the house to prevent voting for granting leave to move a motion of no confidence. If the speaker and the government attempt to circumvent a no confidence motion,
I think it's a historic day. Two very important decisions have been given by the Supreme Court of India in matter of half an hour. The first decision has gone in favor of Arvind Kejriwal. The second decision has given temporary reprieve to the government in Maharashtra. Eknath Shinde's government has survived to fight another day. You know, I'm opening this forum to our various guests who joined with me. First of all, I would like to go to my colleague Ashok Bagaria. Ashok, can you just sum up what has happened in the Maharashtra judgment, and then after that, you know, we'll take a couple of quick comments and then go to the historic Delhi judgment.
Well, Karthikeya, as far as the Maharashtra verdict is concerned, one issue which actually arose out of the arguments has been referred to as 7 judges. Now, what is the issue that has been referred to 7 judges? It deals primarily with the question that suppose that there is a disqualification application before a speaker against some MLAs, and at the same time, there is also a disqualification petition against the speaker. Can the speaker be barred from deciding the disqualification applications of the MLAs? Now, this is something which has been referred to 7 judges. On other aspects, the Supreme Court is still reading out the verdict. It hasn't reached the conclusion stage, but primarily from what we are getting to understand is that number one, they have said that they have clearly said that the chief whip, which is appointed in the state assemblies, is a very important player.
Okay. I think, I think the bottom line, Ashok, is that, so the government in Maharashtra has got time to fight another day. I'm also joined by Kiran Tare. Kiran, a big relief for Eknath Shinde?
Actually, we can't say it's a relief because the Supreme Court has clearly said that the appointment of Bharat Gogawale as a chief whip, who belongs to the Shinde faction, is illegal. That is, I think it could be a legal problem for Shinde camp also, because if their whip is illegal, what will happen to the orders issued by the whip? Whose whip will be considered as the legal, valid, and whose whip will not? That will be the next question. I think that we should wait for the Supreme Court's final judgment.
But Kiran, bottom line is, has the government survived? Kiran, has the government survived or not?
Government has survived so far, it seems, but how long? It's very difficult to say.
So you're saying how long it's difficult? Mr. Mittal, you are a lawyer, bona fide lawyer. What do you make of this judgment? Has the government survived? Has it got oxygen for next 30 days, 40 days, 50 days? Mr. Mittal?
I have my serious doubt about it. Let me tell you two important, or rather three important aspects, since we are more concerned and the observations of the Supreme Court has wide implication as
Mr.
far as
Mittal,
the
I think
10th schedule, the whip aspect is over, number one. Number two,
Mr. Mittal, there's a problem with your audio network. We'll come back to you. Brijesh?
I think, I mean, I agree with Kiran, because one of the key issue is that, that the certain section has gotten transferred to 7 judges constitution bench, but the Supreme Court is still reading out the judgment. And I think, when it says that the speaker taking cognizance of statement of Mr. Shinde did not undertake to identify who was the chief whip, and he should have undertaken an inquiry. So if appointment of the chief whip is illegal, then what happens to the decision which is taken by the chief whip? I think in another 5-10 minutes, when the Supreme Court will finish, the constitution bench of the Supreme Court will finish, we will be in a position to say for sure as to which way this.
Two observations which have come. Ashok, are you there with us?
The governor.
Okay. So the first stage, Ashok, just let me read this to you, Ashok. If the speaker and the government circumvents the no confidence motion, the governor will be justified in calling a floor test. Without the aid and advice of the Council of Ministers, Chief Justice of India, floor tests cannot be used to resolve internal party disputes. Even if it is assumed that the MLAs wanted to ex the government, they only constituted a faction. So what do you make of these obiter dictas, Ashok?
That is what I was trying to tell you, Karthikeya. In fact, what you read out, beyond that also, the Chief Justice of India has gone and said that the governor cannot act upon inferences that a particular political party has lost majority or not. In fact, what I would suggest at this point in time is that we are already reaching the conclusion part of the judgment which Chief Justice Chandrachud is reading out. So if we cut out to him, then we'll probably get a clear picture, point wise, point 1, point 2, point 3, point 4. So if we can cut straight to the verdict, probably we'll get a better understanding instead of just pulling out some observations made here and there.
Okay, let's cut across to the Chief Justice of India.
To conclude that Mr. Thackeray had lost the support of the majority of the House. Second, the governor relied on the letter dated 25 June 2022 from 38 SSLP members, claiming that the security provided to them and to their families was illegally withdrawn. The MLAs claimed that the security was withdrawn to coerce them into continuing to support the MVA government against their free will. Therefore, they demanded the restoration of the security provided to them and to their family members. After receiving the letter, the governor issued directions to the state police to provide adequate protection to the MLAs, the members of their families, and their property. However, the lack of security to the MLAs has no bearing on the question of whether the government enjoys the confidence of the House. The appropriate response of the governor in such cases is to ensure that security that they were lawfully entitled to continues to be provided to them if it has been removed. This was an extraneous reason that was considered by the governor. The third communication that the governor relied on is the letter dated 21 June 2022 addressed by Mr. Eknath Shinde to the Deputy Speaker, stating that the appointment of Mr. Ajay Chowdhury was illegal. The governor may not inquire into or express an opinion on the validity of proceedings of the legislature. That is exclusively within the domain of the legislature itself, or in certain circumstances, discussed in the previous segment of this judgment, within the domain of courts. The discretionary power of the governor under Article 163 of the Constitution is limited to situations where a constitutional provision expressly provides it, or where the Constitution cannot be construed otherwise than to grant such discretion. Hence, the governor ought not to have relied on the letter dated 21 June 2022. In any event, the contents of the letter did not indicate anything to suggest that the then Chief Minister, Mr. Thackeray, had lost the confidence of the House. Finally, the governor relied on the letters written by Mr. Fadnavis and 7 independent MLAs, calling upon him to direct Mr. Thackeray to prove his majority on the floor of the House. First, Both Mr. Fadnavis as well as the 7 MLAs could have well moved a motion of no confidence. Nothing prevented them from doing so. Second, a request by some MLAs for a direction to the Chief Minister to prove his majority does not, taken alone, amount to a relevant and germane reason to call for a floor test. There must be some objective material in addition to a mere request to call for a floor test. In the present case, the governor did not have any objective material before him to indicate that the incumbent government had lost the confidence of the House and that he should call for a floor test. And the exercise of discretion by the governor in this case was not in accordance with law. Now on relief. Relying on Bommai and Nabam Rebia, the petitioners argue that this court has the power to restore the status quo ante and rule that the government with Mr. Thackeray as its chief minister is to be reinstated. However, this argument does not account for the fact that Mr. Thackeray did not face the floor test on 30 June 2022 and submitted his resignation. This court cannot quash a resignation that has been submitted voluntarily. Had Mr. Thackeray refrained from resigning from the post of the chief minister, this court could have considered the grant of the remedy of reinstating the government headed by him. The order of this court dated 29 June 2022 held that the outcome of the trust vote to be conducted on 30 June 2022 shall be subject to the final outcome of this batch of petitions. Since the trust vote was not held, the question of it being subject to the final outcome of these petitions does not, therefore, arise. Conclusions. In view of the discussion above, the following are our conclusions. A. The correctness of the decision in Nabam Rebia is referred to a larger bench of 7 judges. B. This court cannot ordinarily adjudicate petitions for disqualification under the 10th schedule in the first instance. There are no extraordinary circumstances in the instant case that warrant the exercise of jurisdiction by this court to adjudicate the disqualification petitions. The Speaker must decide the disqualification petitions within a reasonable period. C. An MLA has the right to participate in the proceedings of the House regardless of the pendency of any petitions for their disqualification. The validity of the proceedings of the House in the interregnum is not subject to the outcome of the disqualification petitions. D. The political party and not the legislature party appoints the whip and the leader of the party in the House. Further, the direction to vote in a particular manner or to abstain from voting is issued by the political party and not the legislature party. The decision of the Speaker, as communicated by the Deputy Secretary to the Maharashtra Legislative Assembly dated 3 July 2022, is contrary to law. The Speaker shall recognize the whip and the leader who are duly authorized by the Shiv Sena political party with reference to the provisions of the party constitution after conducting an inquiry in this regard and in keeping with the principles discussed in this judgment. E. The Speaker and the Election Commission of India are empowered to concurrently adjudicate on the petitions before them under the 10th schedule and under paragraph 15 of the symbols order respectively. F. While adjudicating petitions under paragraph 15 of the symbols order, the ECI may apply a test that is best suited to the facts and circumstances of the case before it. G. The effect of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members facing disqualification proceedings. The Speaker would prima facie determine who the political party is for the purpose of adjudicating disqualification petitions under paragraph 2(1) of the 10th schedule, where 2 or more factions claim to be that political party. H. The governor was not justified in calling upon Mr. Thackeray to prove his majority on the floor of the House because he did not have reasons based on objective material before him to reach the conclusion that Mr. Thackeray had lost the confidence of the House. However, the status quo ante cannot be restored because Mr. Thackeray did not face the floor test and tendered his resignation. And I, the governor, was therefore justified in inviting Mr. Shinde to form the government at the behest of the BJP, which was the largest political party in the House. This batch of writ petitions is disposed of in terms of the conclusions and directions recorded above.
Grateful to your Lordship.
Bottom line here is that the resignation of Uddhav Thackeray turned out to be his biggest Achilles heel. As Sharad Pawar said, लड़ना तो चाहिए था, बिन लड़े इस्तीफा दे दिया. And today,
exactly.
Justice Chandrachud, Chief Justice, I think mentioned it 4 times in his judgment.
I think Karthikeya, when this entire thing was being mentioned before the Chief Justice, and when both lawyers from both sides were arguing, this was one point which was raised several times by the Chief Justice of India, saying that, if you have resigned on your own and without fighting, then there is not much anybody can do about it. And it was only then it was realized that the chances of, Supreme Court turning back the clock, if I may use the term, does not arise. And it was very clear that at that time it would not have had happened. The fact is that if Uddhav Thackeray would have fought and lost the election, Karthikeya, today the situation could have been something completely different. But yes, the role of the governor has come under serious scrutiny. He has been severely criticized by the Supreme Court, and I think, it once again put the lens back, before of how the governors would act in a partisan manner. And I think this has been very amply illustrated by the Chief Justice of India.
Ashok, to you.
Well, I do agree with what Brajesh is saying. Some very strong words coming against the governor of Maharashtra by the Supreme Court of India. Now, the Supreme Court of India is saying that the governor should not have decided or called Uddhav Thackeray to prove his majority on the floor of the House, primarily for the simple reason that he had no material before him to suggest there was a problem in the government. Moreover, another very important principle as far as defections is concerned, the Supreme Court has said that defense of split is no longer available to political parties. Now, that is the basic scheme under the Constitution as far as the anti-defection law is concerned. And here, in Eknath Shinde and his rebel MLA's case is concerned, the argument taken was that this is not a defection. We haven't defected from one party to another, but in fact there is a split within the political party and we are the original Shiv Sena. So here the Supreme Court is making things clear that this argument of split will not be any longer available. Another very important thing that the Supreme Court says is that if you have a grievance with respect to any order of a speaker or any proceeding on the floor of the House, you cannot come under Article 32 straight away to the Supreme Court saying that there is a violation.
Ashok, I think the sticks have been, the villains have been established. People have got the stick. But Mr. Shinde survives to see another day. Can I say that, sir?
Yeah, Mr. Shinde survives. But in fact, what will have to be kept in mind, Karthikeya, is once we get the fine text of this judgment, there will be another round of litigation which could result from this judgment of the five judges.
So basically survives the day. I would like to go back to the other story, which is a big win. It's a story which is emanating from Delhi. If Maharashtra government would have followed today, maybe we would have been, Brijesh and me would have been counting numbers here. We would have been, calling up our sources in Mumbai. We would have been finding out whether how long Mr. Shinde will survive, whether the meeting of BJP will take place in Deen Dayal Upadhyay headquarters. But now the whole attention, I'm shifting the attention to the boss of Delhi. Delhi now has a boss. And the name of that boss and the face of that boss will be on the screen. And the boss has been empowered. The boss has been empowered by the Supreme Court of India. Yes, I'm talking about one person who has been fighting tooth and nail in Delhi, undefeatable, who has been center of controversy from the way the politics has been conducted, from the liquor scam to the house and the money he has invested. But right now, Supreme Court has made him the boss of Delhi. So Kejriwal is Delhi's new boss. What does that mean for Delhi, Brijesh?
Well, I think, you will again see a spurt of clashes, if I may use the term, because now Arvind Kejriwal has got what he has been asking for a very long time. And I think the judgment of the Supreme Court has cleared several confusion. The Supreme Court judgment, the Constitution bench of the Supreme Court has clarified that, barring issues which have already been earmarked, the bureaucrat of the government, the IAS and the bureaucrats under the joint command, or joint cadre now cannot escape reporting to Arvind Kejriwal. I think it is a big, big win, and all the confusion related to, you know, whether it is the Lieutenant Governor who will run the city, or whether Arvind Kejriwal will have any say whatsoever in running the state, is all gone. Now there's a great degree of clarity, and I think, you know, Arvind Kejriwal will heave it's a big sigh of relief, and Aam Aadmi Party would be an ecstatic party right now, going by you know, the judgment. You know, already we have seen you know, outpouring of tweets by Raghav Chaddha, by Saurabh Bhardwaj, ministers and Rajya Sabha MP, saying that, you know, truth has finally prevailed. I think it's a big day in the life of Aam Aadmi Party, because now they get lot more power. They are now a lot more powerful than they were 24 hours
some
back.
of these tweets are coming. Ye janta ki jeet hai. Saurabh Bhardwaj has tweeted. Ye janta ki jeet hai. So, you know, we know. So now Raghav Chaddha has also tweeted. Honorable Supreme Court landmark judgment sends a stern message that the officers of the government of Delhi are meant to serve people of Delhi through the elected government, not unelected usurpers parachuted by centre to stall the governance, namely LG. So Delhi has a new boss, and the boss is Arvind Kejriwal. So it means जो खिंचातानी चल रही थी वो बंद होगी.
Bilkul. I think, you know, now, you know, the governor cannot have or most of these, you know, bureaucrats who till now would bypass Arvind Kejriwal and report directly and all those, you know, not keeping Arvind Kejriwal or say Aam Aadmi Party or the Delhi government in loop. Now there will be a complete reassessment of that scenario. I think once the transfer and power of posting comes with a government, you know, then it makes the situation altogether different. And, you know, Supreme Court has also said, you know, that the fact that when the bureaucrats, the babus, if they don't report to if they don't report to the state government, then, you know, this accountability is gone.
एक दिन ना वो किताब लिखी जाएगी, 9 Lives of Arvind Kejriwal.
Well, I agree. I completely agree. You know, Arvind Kejriwal, who has been battling this, you know, this entire liquor scam, has got a fresh lease of life.
His ministers are behind the bars.
And he's got a fresh lease of life. And I think, you know, it's a big, big day for Arvind
only
Kejriwal.
Good publicity he has got is that one of his ministers is found to be serenading. He's getting engaged to a very famous actress. That's the only positive publicity he's getting. Apart from that, the only news you get it is of a sheesh smell, of, you know, ministers behind bar, or the people taking cuts, or the anti-corruption issue. And now Supreme Court, you know, comes like a Thor in the whole system and says, well, you are the boss.
See, the point is that, you know, this has been going on for a very long time. You know, the bureaucrats would ignore most of the sermons and look like, you know, that the Delhi bureaucracy had kind of become a party to this ongoing tussle between the LG and the centre. LG and the Aam Aadmi Party government. Now, you know, all that thing has been put aside, set aside. Supreme Court, in a very historic judgment, has completely done away with most of the objections which were raised by the central government. They say if you do not allow it, then the purpose of having a constitutionally elected government is defeated. You have to give it. Supreme Court has also made it clear that when it comes to something which is of national importance, law, land and police, you know, the final call rests with the centre as they have bigger power. But till now it was 100-0, now it is 50-50, and the game is on, going by the kind of testy relationship, you know, Arvind Kejriwal has ever since he came back into power, between him and the BJP and you know, his hate relationship with the Lieutenant Governor.
Okay, you have been talking about the judgment. Let me play out the 2 important bites given by the Chief Justice of India on Delhi verdict.
Now the conclusion. The division of administrative powers between the Union and the NCTD, as explained in this section, must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239 AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239 AA 3A. D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the 3 entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239 AA3 cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H. With reference to the phrase subject to the provisions of this Constitution in Article 239 AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of List 2 of the 7th schedule, because 1. The definition of state under Section 358 of the General Clauses Act 1897 applies to the term state in Part 14 of the Constitution. Thus, Part 14 is applicable to Union territories. And 2. The exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive who are charged with formulating policies in the territory of NCTD would be excluded from controlling the civil service officers who implement such executive.
So Ashok, what was the basic criteria before I play out the bite of Ashwini Kumar, former law minister? What was the criteria on which the judgment went in favor of Arvind Kejriwal? Ashok, what was the criteria because of which the judgment went in favor of Arvind Kejriwal?
Hi, Karthika, you asking me?
Yes, Ashok.
I think he's not able to get your voice.
Ashok, am I audible to you?
Yes, Karthikeya. Okay, is that the question to me?
Yes, that's the question to you. What was the ground on which Kejriwal won?
Well, actually, if you look closely at the Supreme Court verdict, what probably lies at the heart of the verdict is the principle of federalism. The idea of federalism as it is enshrined in the Constitution. The idea of federalism which constitutes the basic structure of the Constitution. Now, this is the core fundamental reason why the Supreme Court has ruled in favor of the Aam Aadmi Party, or let's say Arvind Kejriwal, by saying that the Delhi government will have power to control the services, which in this particular case of Delhi will only include IAS officers and joint cadre officers. The IPS officers will still be away from the control of Delhi government because public order, law and land are issues which are kept away from the control of the Delhi government. These are issues on which only the union government can make laws. Now here, today what we see is, if you take a closer look at what the Chief Justice of India was saying, is that if you look closely at the principles of federalism, the idea of federalism is about sharing of powers. Now, on one hand, you have an elected government in Delhi. The elected government has the power to make laws on certain subjects. But there exists a serious issue that the people who will execute the laws, over them, the Delhi government has no power. That is basically the bureaucracy. They are the executive arm of any government. And the Supreme Court says that the Delhi government is basically has been elected and has been elected by people's will. Now, when that expression of people's will in terms of making law and executing the laws is concerned, the Delhi government has no power. And they say that we cannot, this is not the scheme that the constitution makers had in mind when they formulated this idea of federalism. So they say that, look, we do not agree with this whole idea that is being laid out in Delhi, that, oh, you will have only power to make laws, but as far as control over people who will execute these laws, you will have no power. And in fact, one very interesting thing, let me tell you, Karthikeya and Brajesh, is that during the course of the argument, Manish Sisodia had filed an affidavit in the Supreme Court, and he had brought it to the notice of the Supreme Court that, look, there have been numerous instances when the minister of a department has called for a meeting, and the meetings were to be supposed to be attended by senior officers or officers of the secretary level, joint secretary level. However, what was found is that during these meetings, these officers never turned up, and they sent some junior ranking officer to attend those meetings. Now, why did that situation really happen? Was that all the bureaucrats knew that as far as the transfers and postings are concerned, it will be done by the lieutenant governor. So the loyalty was towards the lieutenant governor or the union government. But now the situation has changed. IAS officers and joint cadre officers now cannot give or look away from the elected government of Delhi. The elected government of Delhi will have power over not just their transfers, but also postings. What we have been seeing till now is that the union government, through the lieutenant governor, has been posting officers in really important departments like finance, health, land reforms, Delhi water distribution, public works departments. But now Kejriwal will be the person who will appoint that which officer will head which department.
Which officer will head which department? Arvind Kejriwal is going to hold a press conference. Before we cut to that press conference for now, let us listen to what former Law Minister Ashwini Kumar has to say.
Well, the decision of the Supreme Court is of far-reaching importance as far as the Delhi administration and its relationship with the central government is concerned. The Supreme Court, drawing on the principles of representative government, democracy and federalism, has clearly held that officers will be responsible to the Delhi government as far as the subjects under the functional and administrative control of the Delhi government are concerned. It has said that only in matters relating to public order, law, public order, land, the decision of the central government through the LG would be final. I think the judgment of the Supreme Court does justice to the constitutional scheme. I think it is only fair to say that the Supreme Court has reiterated a fundamental principle that elected governments must have control over the bureaucracy, which is to discharge the mandate of the elected government. I believe that the judgment will now resolve the contentious issues between the central government and the state government. In all, I think it is a victory on principle for the AAP in the Supreme Court.
सुप्रीम कोर्ट का जो फैसला आया है दिल्ली गवर्नमेंट और जो एलजी के बीच में टकराव चल रहा था, इस फैसले को किस तरीके से देख रहे हैं?
देखिए, एक महत्वपूर्ण फैसला है क्योंकि जो दिल्ली सरकार और केंद्र सरकार के बीच में विवाद चल रहा था अफसरशाही को लेकर, वो आज मैं मानता हूँ समाप्त हो गया है। सुप्रीम कोर्ट ने जो लोकतांत्रिक सरकारों की मर्यादाएं हैं उनके असूलों के मुताबिक ये कहा है कि चुनी हुई सरकारों को अधिकार होना चाहिए अफसरशाही के ऊपर, जहाँ तक उन सब्जेक्ट्स का सवाल है जो स्टेट गवर्नमेंट के कंट्रोल के तहत हैं। जहाँ तक केंद्र सरकार के इख्तियारात हैं, उन्होंने कहा है कि पुलिस, लॉ एंड ऑर्डर और लैंड के जो सब्जेक्ट्स हैं वो केंद्र सरकार के अधिकार में है। तो सुप्रीम कोर्ट ने संविधान के कई प्रावधानों की इंटरप्रिटेशन के बाद ये फैसला सुनाया है। मैं समझता हूँ ये फैसला उचित है, संविधान की मर्यादा के अनुकूल है और इससे जो असहमति का एक टकराव का वातावरण था, मैं उम्मीद करता हूं कि केंद्र सरकार और दिल्ली सरकार में जहां तक अफसरशाही का सवाल है वो ख़त्म होगा।
So there are a couple of tweets which have come out. आम आदमी पार्टी has said कि दिल्ली गवर्नमेंट की सुप्रीम कोर्ट पे बड़ी जीत हुई, चुनी हुई सरकार के पास ऑफिसर्स की ट्रांसफर पोस्टिंग की शक्ति होगी, अधिकारी निर्वाचित सरकार के माध्यम से काम करेंगे, दिल्ली की जनता काम रोकने के लिए केंद्र द्वारा भेजे पैराशूट, एलजी के अफसरों पर कोई नियंत्रण नहीं होगा। सो आई थिंक इज जस्ट रबिंग इट इन। आतिशी सिंह, सालों की लड़ाई के बाद सुप्रीम कोर्ट ने सरकार को उसका हक दिलवाया, दिल्ली की जनता के काम में अब कोई अड़ंगा नहीं लग पाएगा, ये ऐतिहासिक निर्णय दिल्ली की जनता की जीत है।
one more thing which is coming out that
दिल्ली
now
दुगनी गति से तरक्की करेगी, सबको बधाई।
आम आदमी पार्टी Arvind Kejriwal has called a big meeting of all its ministers in the Delhi secretariat, and I think it is right now, if I may use the phrase, there must be an absolute sense of disquiet in the Delhi Babudam, till now, because as Ashok was mentioning, a very, very important point, one of the big grounds of senior ministers of Aam Aadmi Party government was that whenever they would call for a meeting, Kartikeya, no senior officers would turn up. They will always relegate to a junior officer, because, when the thing which bureaucrats fear the most is that who has the power to control their transfer and posting, and that was with the central government. I think a lot has changed ever since that judgment has come out, and I think Arvind Kejriwal and most of his ministers would be grinning from year to year, to see how it pans out, because now he's not not a nobody as far as Delhi power center or power matrix is concerned. Now he's also a force to reckon with.
I think before I close the show, let me take a closing comment from Ashok Bagadia.
Thank you, Kartikeya. What I was trying to tell you was that in the last many months, what we have been witnessing are these visuals of the Lieutenant Governor, Mr. Vinay Saxena, going around the city of Delhi, and he's usually attended to by a retinue of senior civil servants, and he's directing them to carry out this work, that work. Now, all of that will change. All of that will change. It will be the Arvind Kejriwal government which will now be firmly in the driving seats. Till now, what had happened was Arvind Kejriwal was in the driving seat, but he had no control over the gears, the accelerator, or the brakes. These were the things which were controlled by the central government. Now, with the Supreme Court verdict, Arvind Kejriwal is not just firmly in the driving seat, but he also has control over the car called Delhi. He can apply brakes, he can accelerate, he can change gears, he can do whatever he wants. This is the crux of the Supreme Court's verdict as far as the Delhi services case is concerned.
So, do you agree with Vijay? Do you agree with him?
Oh, absolutely, 100%. Right? Because now all the bureaucracy will also start reporting to Arvind Kejriwal, because other than land, power, police, and maintaining law and order situation, rest of the thing is lies with the Delhi government, and now the transfer posting thing has also been given to Delhi government, and Supreme Court has also made it very clear that that apart from things which are already cleared, demarcated under various laws, there is a clear-cut division of who can do what, and the Supreme Court, the Parliament has the power to change, and Parliament is the one who opted for this system in Delhi, where the government is elected, and you cannot render an elected government ineffectual. And he also went on to say that Supreme Court said that if the bureaucrats know that that they do not report to a particular minister, the power to control goes away from them, and they should be held accountable by the political masters, because they are accountable to the people in turn.
Okay. I think on this note, we can have a long conversation, but on this note, I will have to call this conversation off, Brijesh, for one simple reason, because there are other stories to be told, there are other discussions to be held, but this verdict is very, very important. And this verdict is important for one reason, that somehow the federal structure or the federal behavior of the Indian Union or the Indian governance has been emphasized by the Supreme Court of India, that basic principles of functioning.
And it was rendered completely ineffectual. You cannot have a elected state government who cannot do anything.
Absolutely. So I think that is the most important part. That thing has been emphasized, and I think on this note I'll call up this discussion, but somehow I would say that the battle will go on, because Kejriwal is like any other political animal, he's not going to give it up, but then he is the new boss of Delhi. Thank you very much. Thank you, Pradesh. Thank you, Ashok.